8 gun laws were just knocked flat by federal courts, and millions of gun owners still think the old bans are alive. Some of these rules could have turned a normal purchase, a range trip, or a home defense setup into a felony not long ago. It slipped under the radar, the fine print matters, and if you're relying on yesterday's rules, this is a trap. Quick question, are you subscribed yet? If not, hit subscribe right now. You're going to want every update before I break this whole thing down. What makes this so important is that these rulings didn't come out of nowhere. They grew out of one Supreme Court case that changed the whole argument over gun laws in America. Back in 2022, the court decided the Bruen case, and that decision hit like a shockwave through the lower courts. From that point on, judges stopped asking whether a law sounded useful and started asking whether America had a law like it when the Second Amendment was adopted. That sounds simple, but it changed everything. For years, many courts let governments defend gun restrictions by saying public safety was a strong enough reason. After Bruen, that shortcut got much harder to use because judges were told to look backward, not just at modern fears. If the government can't show a real historical match from the founding era, the law is suddenly standing on very thin ice. Now the pressure is showing up everywhere, from handgun sales to ammo rules to what federal agencies can and cannot do. Before I reveal what the court actually said, quick question. Subscribed yet? You're going to want notifications on for this, because once you hear how fast these rulings are moving, you'll understand why so many gun owners are stuck following rules that may no longer hold up. And that kind of confusion can matter the moment you try to buy, carry, store, or transport a firearm. Start with one of the biggest shifts of all, handgun sales to adults between 18 and 20. For a long time, federal law blocked licensed gun dealers from selling handguns directly to that age group. You could be old enough to vote, sign contracts, live on your own, and even serve in uniform, but still get turned away at the counter. Then the Fifth Circuit stepped in and said the government had not shown a deep historical tradition for that kind of age-based federal ban. That ruling matters because it hits real life, not just legal theory. Picture a 19-year-old who lives alone, works late, and wants a handgun for protection inside her home. Under the old federal rule, the answer at the gun store was simple: come back when you're 21. The court looked at that kind of burden and said the government had not earned the power to impose it under the Constitution. And here's the part that made people pay attention. The federal government tried to fight back, but the ruling was not stopped from taking effect. That told a lot of people something important. This was not just a fluke from one restless judge trying to make headlines. It was a sign that higher courts may be more willing than ever to let these challenges move forward instead of shutting them down early. Now shift west, because the next fight wasn't about the gun itself. It was about ammunition, which sounds less dramatic until you remember a gun without ammo is a locked door with no key. California had built a system that required a background check every single time someone bought ammunition, not just when buying the firearm. That meant another hurdle, another delay, and another point where the state could block access to something tied directly to using the gun at all. When the Ninth Circuit looked at that setup, it raised a basic question. If the right exists on paper, but the state keeps squeezing the supply needed to use it, how real is that right? That court, which many people do not think of as friendly to gun rights claims, still found serious constitutional problems with the ammo check system. Even with more legal fighting still swirling around that case, the message was loud. The old playbook is no longer safe. For ordinary people, that is not some courtroom abstraction. It means the law may no longer support extra barriers piled on top of ordinary lawful purchases in the way some states assumed it could. If you go to a store thinking every old restriction is still solid, you may be missing how fast the legal map is changing. And if you live near a state border, that confusion grows fast because one rule can collapse in one place while another survives next door. Then came the waiting period fight in New Mexico, and this one hit the self-defense issue head on. A waiting period means you pay for the gun now, but the state forces you to leave without it and come back later. New Mexico made that delay a full 7 days, and the 10th Circuit said that kind of pause likely crossed a constitutional line. The court saw the obvious problem. Danger does not politely wait for a government timer to run out. Think about a person who has just learned an ex is making threats, showing up or circling the block. In that kind of moment, a week is not a small inconvenience. A week can feel like forever, especially if the law is keeping someone from getting the means to defend life inside the home. The court did not treat that as a minor paperwork issue. It treated delay itself as part of the burden. And when New Mexico tried to get another look from a larger panel of judges, the answer was still no. So that ruling stayed standing, which added even more force to this broader trend. Courts are starting to say the right to armed self-defense cannot be treated like a slow, optional favor from the state. If the need is urgent, the delay can become part of the constitutional problem, not just an administrative detail. Now we get to one of the wildest episodes in this whole story: pistol braces. These were owned by millions of people, and for years many Americans bought them legally under the rules as they understood them. Then the federal government changed course and tried to treat braced pistols as short-barreled rifles under a separate, stricter federal law. That meant registration, a tax, added paperwork, and the threat that ordinary owners could suddenly be treated like criminals. The panic came from how quickly the ground shifted. A setup many people had bought in good faith was suddenly being described as something that could expose them to felony charges. People were told to register, destroy, or change firearms they had owned lawfully, and they were expected to move fast. That is exactly the kind of agency move that has been drawing more and more pushback from the courts. Then the whole thing started to fall apart for the government. Challenge after challenge was filed, judges blocked enforcement, and the rule eventually collapsed instead of tightening its grip. By the time the dust settled, the brace rule was effectively dead at the federal level, and millions of owners were no longer staring at that sudden reclassification threat. The message was simple: a federal agency does not get to rewrite criminal consequences by stretching words beyond what Congress actually passed. Here's something crazy: 87% of people watching right now aren't subscribed. Don't be part of that statistic. If you want these changes explained in plain English before the next rule drops, hit subscribe and stay with me. Because this next part shows why the fight is no longer just about one accessory or one state law. It is also about who gets to make the rules in the first place, and how far agencies can go without Congress. That brings us to another ATF fight, this time over who counts as a gun dealer. The administration pushed a rule that tried to stretch the meaning of being engaged in the business of selling firearms. In plain English, the concern was that private people selling a few guns from their own collection could get pulled closer to dealer territory. And once that line moves, the legal risk for regular owners moves with it. A federal court in Alabama said that push went too far. The judge found the ATF had tried to expand its own power beyond what the law actually gave it. That matters because being treated like an unlicensed dealer is not a slap on the wrist. It can carry very serious federal consequences. So for collectors, hobbyists, and longtime owners who occasionally sell personal firearms, this was a major warning shot against overreach. Still, this is where people need to stay calm and smart. A ruling like that does not mean every private sale is suddenly simple everywhere, or that every state rule disappears overnight. It means the government ran into a hard limit when it tried to widen the net too far through rulemaking. You still need to know the law where you live, but the courts are making clear that agencies cannot just fill in the blanks however they want. Illinois became another flashpoint when a federal judge struck at that state's assault weapon ban. That case is still moving through the system, so this is not the same as a final Supreme Court answer. But the ruling mattered because the court applied the newer Second Amendment standard and asked whether history truly backed a ban on those common firearms. The state had a much harder time answering that question than it would have under the older way of judging gun laws. That is why this issue feels bigger than one state fight. If a court starts viewing commonly owned semi-automatic rifles through the lens of history instead of political language, the whole debate changes. Labels do not do the legal work by themselves. A government still has to show why this kind of ban fits the constitutional tradition, and that has become a much steeper climb than before. Minnesota saw a similar break in the old pattern, this time over carrying handguns in public. The state had rules that blocked adults between 18 and 20 from getting permits to carry. The Eighth Circuit backed a lower court ruling that found that restriction unconstitutional, which lined up with the growing view that adulthood cannot be split apart so easily. If someone is a legal adult with no disqualifying record, courts are increasingly asking why their rights should be cut down just because of age. That matters far beyond one permit office. It affects whether a young adult can lawfully protect themselves outside the home, not just keep a firearm inside it. It also shows how the same logic is spreading from purchase rights to carry rights. Once one age-based restriction falls under history review, others start looking shaky too. And then there is the Supreme Court's bump stock decision, which helped fuel this entire wave. In that case, the court said the federal government had gone beyond the text of the law when it treated bump stocks as machine guns. The key point was not whether people liked bump stocks. The point was that an agency cannot change a legal definition on its own just because it wants a faster path to a ban. That decision sent a message well beyond one device. It told agencies that courts may no longer give them broad room to invent meaning where the statute is clear. And once that signal was sent, every other major gun rule created through aggressive interpretation became more vulnerable. You can see that legal DNA running through the brace cases, the dealer rule fight, and the broader mistrust of agency-made shortcuts. So what ties all 8 of these stories together? It is not just politics, and it is not random luck for gun rights challengers. It is a new constitutional test paired with a new level of skepticism toward agencies trying to do Congress's job for it. That combination is why laws and rules that looked untouchable a few years ago are now getting struck, blocked, or dragged into serious danger. Here is the simple version. Before, a lot of courts asked whether a gun law seemed reasonable enough in today's world. Now they are much more likely to ask whether the country had a similar limit when the Second Amendment was adopted, or at least close enough to that tradition. That shift may sound technical, but it changes the starting point, and once the starting point changes, outcomes change with it. For everyday gun owners, the effect is immediate. It touches who can buy, how fast they can buy, what can be attached to a firearm, and how governments can police access to ammo. It affects what a young adult may be allowed to do, what a collector must worry about when selling, and what rules survive when challenged in federal court. And yes, it can affect what happens when someone is stopped on the road and dealing with state law, permit law, and transport law all at once. That last part is where people get into trouble. They hear that a federal court struck something down and assume every old restriction everywhere vanished in one sweep. That is not how this works. One state may still enforce its own separate law while another state changes course, and one case may still be tied up on appeal while another is already effective. Let me ask you something. If you care about your rights, hit that subscribe button. I'll wait. Because if you miss one ruling and rely on an outdated headline, you could make a bad decision at the worst possible time. The law in this area is moving faster than most people realize, and confusion is now one of the biggest risks, not just for activists or lawyers, but for regular people trying to stay lawful. Take the 19-year-old buyer issue again. A federal age restriction may be falling apart, but that does not mean every state gave up its own age rules. So a young adult could hear, the ban was struck down, then walk into a shop and run into a very different answer under state law. That is why staying informed matters more now, not less, because big rulings often create a patchwork before the dust settles. The same thing is true with ammunition. If one court says a state's ammo background check system violates the Constitution, that does not mean every ammo rule in America disappears overnight, but it does change the conversation, and it tells states that they can no longer assume extra barriers are automatically safe from challenge. That matters if you buy regularly, train often, or simply do not want your rights reduced by endless layers of gatekeeping. Think about the private owner who sells 2 or 3 firearms over time from a personal collection. That person is not running a storefront, not buying inventory, and not acting like a commercial dealer. Yet under a broad enough federal rule, even that person may start wondering whether normal conduct is being redefined into a crime. The Alabama case pushed back on that fear and reminded the government that words in a statute still have limits. And think about the brace owner who followed the rules as they existed at the time of purchase. That person did not wake up wanting to defy federal law. The law changed around them, or at least the agency tried to change it around them, and suddenly lawful ownership looked risky. When courts stopped that rule, they did more than settle one accessory fight. They pushed back against sudden criminalization by bureaucratic decree. The waiting period ruling carries that same kind of human weight. It forces courts and lawmakers to face a hard reality. The need for self-defense is not always scheduled in advance. When danger feels close, telling someone to come back in a week is not a neutral administrative step. It can amount to denying the practical ability to exercise a right at the very moment the person believes they need it most. None of this means people should act recklessly, rush decisions, or treat firearms lightly. The smart response is the opposite. Know the rule where you are, store safely, train seriously, and make choices with a clear head instead of internet rumors. The courts may be cutting down bad laws and bad rules, but that does not remove the duty to act responsibly. And that is a big reason these cases matter so much. They are not really about chaos. They are about lines, limits, and who gets to make decisions that carry criminal consequences for normal Americans. When a state or agency steps beyond those limits, the courts are becoming more willing to say no. That is why this moment feels different from older gun law battles. The old system gave governments broad room to argue safety and win. The new system demands history, text, and actual legal authority, and those are much harder to fake. If officials cannot show the tradition, or if an agency cannot point to real statutory power, their position is suddenly much weaker. The information I'm about to share could literally save you during a police stop. But first, are you subscribed? Hit that button now because the final piece of this story is the one that affects every gun owner, even if they never go to court. What matters in real life is not just who won a case. What matters is whether you understand the current rule before you buy, carry, transport, or answer questions from law enforcement. Here's the bottom line. These 8 rulings and court fights show that the legal map is being redrawn in real time. A federal handgun age ban for adults 18 to 20 has been struck by a major appeals court. California's ammo background check system took a major hit. New Mexico's waiting period was ruled unconstitutional, and Minnesota's carry age rule was knocked down as well. Add in the collapse of the federal pistol brace rule, the block on the ATF's dealer expansion, the serious strike against Illinois' rifle ban, and the Supreme Court's bump stock ruling. Put all of that together, and you are looking at a historic shift, not a one-day news cycle. Some of these fights are still moving, and some outcomes may change again. But the direction is impossible to miss. Courts are demanding stronger constitutional footing than governments have gotten used to providing. So the personal stake is simple. If you own a gun, want to buy one, plan to carry, or keep one for defense at home, these cases touch your world directly. They affect what is legal, what is challengeable, and what may no longer be enforced the way it once was. And in a legal climate changing this fast, being uninformed is no longer a small mistake. It can be the difference between confidence and costly confusion.